Welcome back to Due Process Daily. Imagine walking into a courtroom alone. No attorney by your side, no legal team behind you. Just you, your paperwork, your nerves, and the hope that you're prepared enough to win. Sounds terrifying, right? But what if I told you that thousands of people do this every single year, some out of choice and others out of sheer necessity? The question is, can you really represent yourself in court and win? Welcome back to Due Process Daily, where we break down the legal system in plain language so you can understand your rights, your risks, and your reality. Today, we're diving into pro se litigation. That's the official term for representing yourself without an attorney. Now, before you think this is only for conspiracy theorists who refuse to pay lawyers, think again. In small claims courts, pro se litigants are the majority. These courts are almost designed for people to represent themselves. There are simplified rules, smaller monetary stakes, and usually the judge will be a bit more lenient with procedures. In fact, most people who sue someone over a broken contract, a damaged car, or an unpaid loan under a few $1,000s do it without hiring a lawyer. But what about the bigger cases? What about representing yourself in a divorce, a child custody case, a civil lawsuit over property, or even in a criminal proceeding? That's where the stakes rise. And so do the risks. Let me tell you a quick story about a man named Greg. Greg decided to represent himself in a custody dispute. He figured, I know my child better than any lawyer ever will. Why would I waste $10,000 paying an attorney to tell my story when I can tell it myself? Greg read up on family court procedures, watched videos, and even practiced what he was going to say in front of his bathroom mirror every night. But when court day came, he was unprepared for the barrage of objections, procedural motions, and legal terminology thrown at him by his ex-wife's attorney. He didn't know how to introduce evidence properly. He didn't know how to object to certain testimony. He didn't know that the parenting plan he submitted didn't follow state guidelines, which made it legally invalid. By the end of the hearing, the judge awarded primary custody to his ex-wife, and Greg walked out of the courtroom stunned. Now, is Greg's story unique? Unfortunately, no. Studies show that pro se litigants lose far more often than represented litigants, especially in family court and civil suits involving complex rules. Judges are supposed to remain neutral, and while they can give some leeway to people without lawyers, they cannot give legal advice or tell you how to argue your case. That's something many self-represented litigants misunderstand. They think, if I don't know something, the judge will help me. But judges are prohibited from assisting either side because their role is to be impartial. There are horror stories of pro se litigants getting their entire cases thrown out because they missed one procedural step, like failing to file a motion within the deadline or failing to serve the opposing party correctly. Imagine spending months preparing your case only to have it dismissed because you didn't follow a technical rule. But let's flip the coin. There are also success stories. Take Sarah, for example. She was sued by a debt collector for an old credit card debt. She couldn't afford a lawyer, so she started researching consumer debt defense. She learned about statutes of limitations, how to demand proper proof of debt ownership, and how to question the collector's evidence. When she went to court, she calmly explained to the judge that the debt collector failed to provide an original signed agreement or valid assignment documentation. The judge dismissed the case. Sarah walked out feeling like she'd just beat Goliath. So what's the difference between Greg and Sarah? Preparation and the type of case. In debt collection defense, many creditors buy debts in bulk and lack the documentation to prove their claims. For someone like Sarah, reading up on a few specific defenses gave her the tools to protect herself. In family law or criminal law, however, you're dealing with layers of legal complexities, evidentiary standards, and strategic decisions that go far beyond reading court rules online. If you're considering representing yourself in court, ask yourself these 3 questions. First, do you understand the procedural rules for your court and type of case? Court rules are not just suggestions. They are mandatory, and failing to follow them can sink your case instantly. Second, can you handle the emotional stress of litigation while thinking strategically and objectively? Representing yourself means cross-examining witnesses, responding to objections, and controlling your emotions under pressure. Third, are you risking your freedom, custody of your children, or large amounts of money? If the stakes are high, the cost of losing far exceeds the cost of hiring a lawyer. Now, let's talk about criminal cases. Yes, you can represent yourself in a criminal case. The Sixth Amendment gives you that right, but judges will often strongly warn you against it. In fact, if you insist on representing yourself, most courts will hold a Feretta hearing to ensure you understand what you're doing. Why? Because the risks are severe. You could go to jail for months or years. And if you don't know how to negotiate a plea deal or argue constitutional violations, you may end up with a conviction on your record that could have been avoided. You might be thinking, but what about all those sovereign citizens who go to court quoting the Constitution, maritime law, and random YouTube legal theories? Well, here's the truth. Those individuals almost always lose. Courts do not accept pseudo-legal arguments. Judges often find them frivolous, and in some cases, people have ended up with contempt charges or higher fines for refusing to follow proper procedure. So when should you represent yourself? If you're dealing with a small claims case under your state's monetary limit, or if you're fighting a debt collection lawsuit with clear procedural defenses and you have the time to study your court's rules, it might be worth trying pro se. But if you're facing a divorce involving custody disputes, a criminal charge, or a civil suit with tens of thousands of dollars at stake, hiring a lawyer is almost always the better choice. The court system is not a reality TV show. It's not about who has the most dramatic story or the loudest voice. It's about procedure, evidence, and strategy. Even lawyers hire lawyers to represent them because objectivity is impossible when your own freedom or finances are on the line. At the end of the day, representing yourself can be empowering if you're fully prepared and understand what's at risk. But if you choose to go down that path, prepare like your life depends on it, because in some cases, it does. Thanks for watching Due Process Daily. If you learned something new today about pro se litigation and the risks of representing yourself, make sure to subscribe to the channel, like this video, and share it with someone who might be thinking about taking on the court system alone. Let me know in the comments below if you've ever represented yourself in court and what that experience was like for you. Until next time, stay informed, stay prepared, and never walk into a courtroom without knowing exactly what you're doing.